हेलो फ्रेंड्स, दिस इज गोइंग टू बी अ पार्ट 2 ऑफ द डेटा प्रोटेक्शन बिल वाला वीडियो। हमने पिछले वीडियो में ऑलरेडी बात कर ली थी कि डेटा प्रोटेक्शन बिल की एप्लीकेबिलिटी कहाँ कहाँ आती है। ये जो हमारा डेटा फिड्यूशरीज जो होते हैं, द पीपल हु आर कलेक्टिंग आवर डेटा फ्रॉम अस, उनके की ऑब्लिगेशंस क्या होते हैं, एंड फाइनली जो डेटा प्रिंसिपल है, द कंज्यूमर, यू एंड मी, व्हेन वी गिव आवर डेटा, व्हाट आर द राइट्स दैट वी हैव। एंड इसी के अंदर वी ऑल्सो स्पोक अबाउट राइट टू बी फॉरगॉटन. Now, in this video, we're going to have a quick wrap up of the whole data protection bill, and in this, we'll cover a few different provisions of the bill itself. ठीक है, छोटे छोटे provisions हैं, so let's just get into the video itself. Now, the first provision that we're going to talk about here is the cross-border transfer of data. This is very important when it comes to डेटा प्रोटेक्शन बिल. आज मेरा जो डेटा यहाँ पे इंडिया में कलेक्ट किया जा रहा है वो बॉर्डर के बाहर जा रहा है, तो किस हिसाब से जा रहा है, व्हाट आर द डिफरेंट प्रोविजंस दैट आर कमिंग फॉर क्रॉस बॉर्डर ट्रांसफर ऑफ डेटा. तो इसके अंदर वी हैव थ्री प्रोविजंस. थ्री प्रोविजंस दैट आर लेड बाय द डेटा प्रोटेक्शन बिल. द फर्स्ट प्रोविजन दैट इज गिवन बाय डेटा प्रोटेक्शन बिल, इट सेज दैट कि हम ना पर से वी वोंट बी सॉर्ट ऑफ रिस्ट्रिक्टिंग एनी क्रॉस बॉर्डर ट्रांसफर ऑफ डेटा. But there are certain types of data that needs certain amount of regularization, right? So अब जो regularization वाला data है वो हमने already बात की थी कि sensitive personal data, there is a category of personal data known as sensitive personal data, which is above and beyond identification of a person, and it tells you inferences about a person. ठीक है, तो वो जो sensitive personal data होता है, sensitive personal data, उसके लिए the data protection bill says that the first provision under cross-border transfer of sensitive personal data is that any sensitive personal data needs to be stored locally. Any data that is being transferred which is of sensitive personal nature should be stored locally in India itself, right? Second है कि जब डेटा फिड्यूशरी हमारा जो पर्सनल डेटा है, डेटा प्रिंसिपल का पर्सनल डेटा, ही इज अबाउट टू ट्रांसफर इट अक्रॉस द बॉर्डर, देन ही हैज टू टेक एन एक्सप्लिसिट कंसेंट फ्रॉम द डेटा प्रिंसिपल कि मैं आपका डेटा अब दूसरे कंट्री में देने जा रहा हूँ, तो मेरे पास आपसे परमिशन है कि मैं ये डेटा ट्रांसफर करूँ या नहीं. सो दे हैव टू टेक, doesn't matter इससे पहले how many consents they have taken, or they can have all the consents that they have, but in this case when they are about to transfer data to a different country, at that point they have to take a new consent. उनको आपसे आके पूछना पड़ेगा कि मैं ये डेटा ट्रांसफर कर सकता हूँ या नहीं. And इसके ऊपर over and above there the data fiduciary taking an explicit consent, they also have to abide by certain rules that are set under the data protection bill. The first rule is that कि अगर किसी फॉरेन कंट्री के साथ कोई कॉन्ट्रैक्ट है या स्कीम है जिसके अंडर आप ये डेटा ट्रांसफर कर रहे हैं, तो इस कंपनी द कॉन्ट्रैक्ट और द स्कीम, इसका जो अप्रूवल है वो इट शुड बी गिवन बाय द सेंट्रल गवर्नमेंट इन कंसल्टेशन विद द डेटा प्रोटेक्शन अथॉरिटी और DPA. So first, if there is a contract or scheme, the approval should be given by the central government in consultation with the DPA. So the central government will give in consultation with the DPA, they'll give an approval. And the second, it says that the central government itself will conduct something known as an adequacy determination test. They'll conduct an adequacy determination test, जिसमें what they'll see is this data that is being transferred. आपका जो डेटा है, ये डेटा फिड्यूशरी दूसरे कंट्री को दे रहा है, कि ये दूसरा कंट्री किसी फॉरेन गवर्नमेंट को नहीं दे रहा, या फिर किसी और को किसी और पर्पस के लिए तो नहीं दे रहा. इसके लिए सेंट्रल गवर्नमेंट विल कंडक्ट अ एडिक्वेसी डिटर्मिनेशन टेस्ट, एंड इस एडिक्वेसी डिटर्मिनेशन टेस्ट के आधार पर अगर किसी फॉरेन कंट्री को देना है तो वो हाँ बोलेंगे या ना बोलेंगे. So based on this adequacy determination test and the explicit consent of the data principal, then and only then the data fiduciary will transfer your data across borders. And the final thing that the data protection bill says is that they create a category of critical personal data. ये जो कैटेगरी है वो सिर्फ क्रॉस बॉर्डर ट्रांसफर ऑफ डेटा के लिए बनाई गई है. क्रिटिकल पर्सनल डेटा का कोई डेफिनेशन नहीं है डेटा प्रोटेक्शन बिल के अंदर. एंड ये इसलिए है बिकॉज टुमारो एज द लैंडस्केप चेंजेस द लॉ इटसेल्फ नीड्स टू हैव अ फ्लेक्सिबिलिटी वेयर दे कैन चेंज अकॉर्डिंग टू द चेंजिंग टाइम्स. तो इफ देयर इज सर्टन सॉर्ट ऑफ डेटा दैट कम्स एंड दैट द लॉ पुट्स अंडर द क्रिटिकल पर्सनल डेटा, फिर वो ट्रांसफर नहीं किया जाएगा. उसको ट्रांसफर करने के लिए इसके ऊपर एक सीधा प्रोहिबिशन लगेगा कि क्रिटिकल पर्सनल डेटा हम ट्रांसफर नहीं करेंगे एक्सेप्ट इन 2 cases. The first case would be when it relates to a health or public emergency, health services या public emergency या emergency services के लिए. That's the first exemption. And the second exemption is that if the government has done an adequacy determination test, if the government has done an adequacy determination test has been performed and they've seen कि ये जो critical transfer of data हो रहा है, this is not somehow affecting the security or strategic interest of the nation, then we are going to give a go ahead for this. So ये था हमारा cross border transfer of data. These 3 provisions under which cross border transfer of data is guided by. Now in all the provisions that we've spoken about, की ऑब्लिगेशंस हमने देखे, हमारे राइट्स के बारे में देखा, हमने अभी क्रॉस बॉर्डर ट्रांसफर ऑफ डेटा के बारे में देखा. सो व्हेन दीज प्रोविजंस आर नॉट बीइंग मेट, देन देयर आर सर्टेन ऑफेंसेस बीइंग कमिटेड कि डेटा फिड्यूशियरी ये ऑफेंस कमिट कर रहा है बाय नॉट मीटिंग द गाइडलाइंस सेट बाय द डेटा प्रोटेक्शन बिल, एंड बिकॉज ऑफ दिस सर्टेन पेनल्टीज विल बी अप्लाइड ऑन देम. हमने GDPR के टाइम पे भी देखा था, देयर आर ह्यूज पेनल्टीज एंड सिमिलर ह्यूज पेनल्टीज आर बीइंग केप्ट फॉर डेटा फिड्यूशियरीज हु आर कमिटिंग ऑफेंसेस व्हेन इट कम्स टू प्रोटेक्शन ऑफ डेटा. उसमें 2 बास्केट्स बनाए हैं. 2 बास्केट्स हैं. पहला बास्केट है 15 CR का और 4% ऑफ द कंपनीज ग्लोबल टर्नओवर ऑफ दैट ईयर, ऑफ द लास्ट ईयर. उनका 4% ग्लोबल टर्नओवर फ्रॉम लास्ट ईयर या तो 15 करोड़, एंड द सेकेंड वन इज 5 CR और 2% ऑफ द लास्ट ईयर का global turnover of that company. And this will be based on the type of offense being committed, how this offense is being committed, what is the severity of the offense, and ये सब कुछ जब डिसीजन हो जाएगा. ये कब होगा? जब डेटा प्रोटेक्शन अथॉरिटी एक इंक्वायरी ऑफिसर बिठाएगा. अच्छा याद रखना, द इंक्वायरी ऑफिसर हियर हु इज सेट अप बाय द डेटा प्रोटेक्शन अथॉरिटी हैज द पावर ऑफ अ सिविल कोर्ट. So it can send summons and it can do everything that a civil court can, right? So the data protection authority, after an inquiry has been conducted, then they can go ahead and put these fines on the data fiduciary. अब इसके थ्रू अगर because of certain offenses being committed, अगर पर्सनल द डेटा प्रिंसिपल का कोई हार्म हुआ है, उसके लिए भी कंपनसेशन के सारे प्रोविजंस इसी ऑफेंसेस एंड पेनल्टीज के अंदर आते हैं. एंड एक जो बहुत बड़ी अब बात यहाँ पे आती है, दैट इज द डेफिनेशन ऑफ हार्म. When they say that compensation will be given for harm committed on the data principle, the definition of harm is a lot bigger than what is there in GDPR. GDPR का जो harm का definition है, यहाँ पे harm के अंदर आ जाएगा हमारा mental bodily injury, mental injury, restriction of your rights of freedom of speech, psychological manipulation, surveillance, anything. And it's a big broad definition under harm, which is much broader than GDPR. So all in all हमको दिख रहा है कि if harm is being conducted and if the definition of harm is so much, that means the law is that much strict when it comes to privacy of a person, right? So the definition of harm of the data protection bill is a lot bigger. It's a lot bigger than GDPR. ठीक है? Now moving on, we have a term called significant data fiduciaries. Significant data fiduciaries वो होंगे जिनका volume of processing of personal data is very high, or the type of data data being processed is very sensitive, or both, right? Or both. So significant data fiduciaries वो fiduciaries होंगे जिनके पास बहुत सारा डेटा है. Facebook can be one of the significant data fiduciaries. Instagram could be one of the significant data fiduciaries. Any financial network, any financial like fintech sites which has financial information of the data principal would come under significant data fiduciaries. इसमें number of participants will also determine number of active users or participants will also determine if it's a significant data fiduciary or not. But इस category को लाया क्यों गया है? इस category को इसलिए लाया गया है because not all entities which are processing your data, not all data fiduciaries are the same. So the data fiduciaries who are so big, they should have some extra steps to secure the data of the data of the people. Because if they have huge volume of data, they can use that data in n number of ways. It could be for political gain, for political skewing of opinions, could be for religious skewing of opinions, could be any sort of thing that can be done. This is something that was being done during the US elections with Twitter, right? There was this whole false narrative of the election being stolen, right? So similar things could be done. So उस चीज को prevent करने के लिए डेटा प्रोटेक्शन बिल बोलता है कि there has to be a category of significant data fiduciaries. And because if they are being termed as significant data fiduciaries, they'll have certain provisions that put more restrictions on them, more foundations on them. So the first foundation comes from they need to do a data protection impact assessment, DPIA. They have to do a data protection impact assessment. By doing this, they are going to check उनकी security कैसी है, उनका जो security architecture है वो कैसा है, how will they prevent any sort of data breach, and based on this data impact assessment is when they'll be given certain they'll be given a seal of approval by the DPA if they do well in the data protection impact assessment. ठीक है? The next thing that needs to be done for these big significant data fiduciaries is that they'll have to keep a record of all the data that they have and make sure their systems are periodically audited. Their systems are periodically audited. They keep a record of everything that is happening so that any sort of false or breach, any sort of problem could be traced back. And finally, they need to appoint a data protection officer. They need to appoint a data protection officer. If you have such a big company, then you need a specific person who will make sure that you are abiding by every rule and regulation being laid down by the the data protection bill. And also, in case of an issue that has emerged, there should be a body, a person with whom people, the data principals, can have a direct communication with, and this body himself can have a direct communication with the data fiduciary while also connecting to the data protection authority. So this data protection officer is going to be a connection point for the consumers, connection point for the fiduciary, and a connection point for the data protection authority. ठीक है? So this tells me that ये significant data fiduciaries कौन होंगे, and because they are called significant data fiduciaries, इनके ऊपर क्या extra obligations आएंगे? Data protection impact assessment, record and audit of their data, very periodic record and audit of their data, and having a data protection officer appointed by themselves. ठीक है? Now, there are certain exemptions that the bill lays down to make sure that the bill is not very, very restrictive on the state itself. Because agar koi law aa raha hai, which is for the benefit of the person, you will always have to, this is something you must have read in fundamental rights when you're doing your polity, that if certain rights are giving freedom to the citizens, but at the same time restricting the state. So there has to be a balance maintained. And to maintain that balance, the data protection bill assigns certain number of exemptions. The first exemption that they assign is that जो government agencies होंगी, government agencies any government agency who needs to assure that the data that who needs to assure that sovereignty and integrity of India, public order is maintained, who needs to ensure that foreign relations with foreign states is maintained, no incitement of violence happens. Making sure of all these things, the Data Protection Bill says that a government agency can get a written order done from the central government to be exempted from the Data Protection Bill to provide security, sovereignty and integrity for India, right? So that for conducting these provisions for India is not a problematic scene when it comes to the Data Protection Bill. So the first exemption is to government agencies who are working for the sovereignty integrity of India, making sure that sovereignty integrity of India, public order, relations with foreign state, and incitement of violence doesn't happen. So for that, certain exemptions are given under the Data Protection Bill. The next exemption is how personal data is used. How personal data is used and how the consent is used. So the exemption for the second one is when consent can be exempted. Consent is not required. वो कब होगा? जब a person is processing his own personal data. अगर मैं अपना data process कर रहा हूँ, मुझे अपने से consent लेने की कोई ज़रूरत नहीं है. So personal data के लिए I don't need consent. Then, in case of an investigation or an inquiry, if the authority which is conducting an investigation authority, it comes back to the government agencies wala exemption. If an agency is conducting an investigation or inquiry, in those cases, we've already seen this in the key obligations as well as the rights, if in certain cases where security of India is in consideration, in that case, you can work with personal data without taking consent. Then similarly, if the data is being processed by courts or tribunals, in that case also, in case of courts and tribunals, the data can be processed in a way where the consent is not required, right? Similarly, the government says that if there needs to be archiving or statistical analysis to be done for research and development purposes, in that case also, after obviously going through certain obligations laid down by the Data Protection Bill, there could be certain exemptions where consent of the person is not required. And finally, it also says for journalistic purposes, obviously, by abiding by a code of ethics laid down by the Press Council of India, for journalistic purposes, be it for investigative journalism or anything, there are certain exemptions that are provided where you don't require the consent. And the final exemption comes for certain sandbox measures. Sandbox measures क्या होता है? Exemptions के अंदर Data Protection Bill बोलता है कि कल India wants to develop its own AI, India wants to develop its own machine learning, and for these things we might require processing of personal data to be done. So in that case, government with particular approvals and with consultation with the Data Protection Authority itself will create a sandbox. Sandbox का मतलब ये होता है कि you have an area, a restricted area, जो playground में हम धूल मिट्टी के साथ खेलते नहीं थे, where you have a lot of sand and you can make sand castles or anything. It's basically an area for research, of trial and error and research, right? So for that you need a lot of data, especially when you're training an AI or a machine learning or deep learning. इसके लिए you need a lot of data, and for that you need particular personal data. You can't just be making an AI with non-personal data for personal use. So for that case, the government lays down certain exemptions, and obviously that comes through consent of people. उनको बताया जाता है कि आपका जो डेटा है वो 12 महीने से ज़्यादा यूज़ नहीं किया जाएगा, जो डेटा है वो किस हिसाब से यूज़ किया जाएगा, नहीं यूज़ किया जाएगा. Everything is being told to the data principal whose data is being taken. But for those measures, certain exemptions are given under the Data Protection Bill for these sandbox measures for emerging technology, which is still being done for public interest, right? So these were the exemptions. One was the government agencies, which require to provide security, sovereignty, integrity of India. For these agencies with certain written approvals, there's a exemption under the Data Protection Bill. Certain situations where consent is not required, exemption from taking consent of the data fiduciary. Again, we spoke about those. And then finally, sandbox measures, where to develop key technologies in public interest, the Data Protection Bill is going to create some exemptions for them, right? And now finally we talk about this Data Protection Authority, जिसकी बात हम अभी तक करते हुए आए हैं. Data Protection Authority is going to be the regulatory as well as the investigative body. This is going to be a statutory body under the Data Protection Bill. अब Data Protection Authority के अंदर आएगा एक one full-time chairperson. It will also have 6 full-time members, out of which the Data Protection Bill says that out of these 6 members, at least one of them should be a law expert, right? So one chairperson, 6 full-time members, out of which one should at least one could be more than one, but at least one should be an expert in law, right? And ये appoint कैसे किए जाएंगे? Data Protection Bill has a provision of creating a committee that will appoint the chairperson and the full-time members. अब Data Protection Authority का काम क्या होगा? First, it is a regulatory body. It is going to make sure that there is a regularization of processing of data. How the rules and measures that are taken for processing of data should be regularized all over India, and more so, it should be regularized for all the data that is being processed for Indians, be it inside or outside India, right? So regularization of that. The second thing that they're going to look into is codification and implementation of all the provisions that are laid down by the Data Protection Bill. So the Data Protection Authority is the head body, which is also going to look into how all these provisions that are being laid down by the Data Protection Bill, ये जितने भी provisions हैं, ये कहाँ कैसे किस हिसाब से apply किए जाएंगे, ठीक है? And finally, they will also enforce compliance of the Data Protection Bill through data protection officers, through an inquiry officers, and having all the codification and implementation of all the laws that are being laid down by the Data Protection Bill. Now, this concludes our conversation on Data Protection Authority, on Data Protection Bill, on data fiduciaries, and all in all, the whole right to privacy wala chapter. We've already spoken about right to privacy, its history, how it came about, the Indian legislations that were the key deciding factors for right to privacy being today counted as a fundamental right. So I hope you really enjoyed these videos, and this gave you a complete clarity on right to privacy. In the next video, we're going to start our rights discussion for women's rights, and that's the topic we are going to look at. So I hope you loved the videos, and I'll see you in the next video.